Garden State GSCLE. 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 Garden State GSCLE.
Jews today are probably the most disproportionate members of the bar compared to their presence in the total population. And so in a sense, Jews have been deeply involved in American law for a very long time, and certainly since the 1960s, especially in the Northeast, the presence of Jews in the law is neither remarkable nor surprising. It is simply omnipresent. What I would like to talk about, though, is sort of a general history of Jews in American law and perhaps introduce you to some surprising developments that have taken a long time to play out. And part of my argument is that while Jews are, in fact, major players in law, American law has not been particularly friendly to Jews, and the Supreme Court in particular has been particularly unfriendly to what are essentially Jewish issues. And so I will get to that in a few minutes. First, I want to start with the beginning, because of course we always start in the beginning. And the beginning of the settlement of America is essentially the settlement of America by Protestant groups who come here not to establish religious freedom, but to establish their own particular brand of religion for themselves. So if we look at the first American colonies, Virginia is started by the Crown. It is an Anglican colony. There is only one church in Virginia. It is the Church of England. The second colony is Massachusetts Bay. The separate colony is Plymouth Colony, the Puritan colony, which again is... Blew that one twice. That's fun. Okay, the second colony is Plymouth, which is a separatist colony. Separatists are different from Puritans in the sense that they want to separate from the Church of England as opposed to Puritans who want to purify the Church of England. The separatists in Plymouth start the colony as a separatist colony. They're not interested in seeing anybody else there. The Puritans come 10 years later, create Massachusetts Bay. Similarly, Massachusetts Bay is for Puritans. They are not interested in anyone else, although they, by law, must allow Anglicans to settle. In none of these places is there anything that we would call religious diversity. And in fact, the Puritan colony, Massachusetts Bay, is notorious for kicking out people who diverge from Puritan orthodoxy. Most famously, of course, Anne Hutchinson is kicked out of Massachusetts Bay and ultimately moves to what is today the Bronx, and we remember her most because there is a river and a parkway named for her. And Roger Williams is going to be sent back to England, where undoubtedly he would have been jailed, but instead he is probably allowed to escape from the jail in Massachusetts Bay, and he starts the Rhode Island colony. Rhode Island is the first colony to allow religious diversity. Williams does not believe in religious persecution, but religious diversity in early Rhode Island is simply a colony of different kinds of Protestants. Maryland is started as a haven for English Catholics, and one would think that therefore there's certain religious freedom in Maryland. And in 1649, Maryland passes what's known as the Maryland Toleration Act. And if you look in your textbooks, if you remember back to any American history you may have taken, the Maryland Toleration Act is always given as the first formal statement of religious freedom. But listen to what the Maryland Toleration Act says. that whatsoever person or persons within this province and the islands thereunto belonging shall from henceforth blaspheme God, that is, curse him or deny our Savior Jesus Christ to be the Son of God, or shall deny the Holy Trinity, the Father, Son, and Holy Ghost, or the Godhead of any of the said three persons of the Trinity, etc., etc., that person shall have his lands forfeited and shall be punished with death. And in fact, a Jew in early Maryland is prosecuted and sentenced to death, not for blaspheming Jesus Christ, not for attacking the Christian faith, but rather because he simply refuses to acknowledge that Jesus is the Son of God. He refuses to acknowledge Christian theology. So toleration in Maryland simply means that you allow Catholics to be Catholics and you allow Anglicans to be Anglicans, and you don't allow anybody else to have any religious views. There are, of course, no Jews in what becomes the United States until 1654. And in 1654, a group of 20 or so Jews arrives in what is then New Amsterdam in the New Netherland colony. Now, these Jews are escaping from what had been a Dutch colony in Brazil, and when the Dutch colony was overrun by Portuguese forces, all the Jews were forced to leave because they, of course, now face the Inquisition. And so the Jews go mostly back to Holland, but some of them, this one boatload, ends up in New Netherland. And when they arrive, they are met at the boat by not Peter Stuyvesant, who we always think of because he's the mayor of New York. Rather, their boat is met by the other Jews who were already in the New Netherland colony. And so for those of you who went to Sunday school many years ago and read about the first Jews to come to the New World, they are met at the boat by the other Jews who preceded them. There are 4 or 5 other Jews living in New Netherland at the time. All of them have come directly from Holland, and all of them are accepted and living, and no one has questioned their right to be there. But when this small group of 2 or 3 families arrives, there is conflict, and Peter Stuyvesant, the Governor General of the colony, tries to kick them out and send them back to Holland. Now, why does he want to get rid of them? Well, part of it is because they're Jews, and Stuyvesant's language reflects traditional 17th century European anti-Semitism. He talks about the Jews as being usurers and as being troublemakers and as undermining the colony. But the reality is that Stuyvesant wants to get rid of them because they are not Dutch Reform, not because they are Jewish, because in fact, within 2 years, Stuyvesant forgets all about the Jews and spends his time persecuting Quakers and Lutherans. And he is much more hostile to Quakers and Lutherans. He jails the local Lutheran minister. He jails Quakers. He beats Quakers. He is incredibly vicious towards Quakers and Lutherans. Whereas with the Jews, all he does is write nasty letters back to the Dutch West Indies Company in Holland saying, please let me get rid of these people. I don't like them. Now, what happens is the Dutch West Indies Company responds to these letters by telling Stuyvesant, we understand that you wish you didn't have any Jews there. We sympathize with you not wanting to have Jews, but you know, we need colonists, and they're there. Leave them alone. And within the space of 2 or 3 years, the Jews in New Amsterdam are settled. They are working their way into a colony, into a community. Now, this is a community where there is not religious freedom, where there is not religious toleration, and where citizenship and other issues are intrinsically tied to one's particular religion or ethnicity. So, for example, in 1655, the local officials go to one of the Jews in the colony, a man named Osser Levy, who is an Ashkenazi Jew who had not come from Brazil, but had come directly from Europe, probably initially from Poland. And they go to Osser Levy, and they ask him to pay the fine that every man has to pay if he won't stand the night watch. And Levy responds by saying, who says I won't stand the night watch? Give me my blunderbuss, I'll stand the night watch. And the government responds by saying, well, Jews never stand the night watch. Jews aren't soldiers. Now, of course, in Brazil, there had been hundreds of Jews who had been part of the private army of the Dutch West Indies Company that helped first take the Portuguese colony and then ultimately lost the Portuguese colony. But they say you can't stand the night watch. And furthermore, they say the other men in the night watch won't want to be in a night watch with a Jew. And Osler-Levy says that's their problem, not mine. This goes on for a couple of years. And in 1656, Osler-Levy once again says, I want to stand the night watch. He's allowed to stand the night watch. And in 1657, he insists that he be made a burgher, that is, a citizen of the city, on the basis of the fact that he stands the night watch. And this is one of the earliest examples we have of Jews using a kind of a legal culture to begin to be admitted formally to the society that they are living in. And so Osler-Levy and 2 or 3 other Jewish residents of New York, what is still New Amsterdam, become burghers of the city. And by the time the British come, there are a number of Jews who are considered to be citizens of the city, and after the British arrive, there is no question but that Jews are entitled to the same citizenship as other people within the British Empire. By the end of the 1660s, there are a significant number of Jewish property owners, and when the British arrive in 1664, the first Jew to buy land under British law is the same Osler-Levy. So this is the evolution of citizenship for some Jews in one place in an early colony. But this is not at all universal. So that Jews can vote in New York, but they cannot vote in Pennsylvania or in Rhode Island. On the other hand, South Carolina is formed in the 1680s, and South Carolina begins its formation by declaring absolute religious freedom for anyone, and Jews are allowed to form their own synagogue, and they are allowed to be members of the community. And again, in Georgia, very early on, there is a Jewish community. So that by the time of the American Revolution, you have Jews scattered up and down the American coast. There are Jews from Georgia all the way through to Rhode Island. There is still no Jewish community in Boston to speak of. There is a fairly vibrant Jewish community in Philadelphia and in New York and in Savannah and in Charleston. When the new states write constitutions, after the Declaration of Independence is announced, they set up the rules for citizenship and voting. Now, what is fascinating is that none of the new states that write constitutions have a restriction on voting based on religion. So all Jewish citizens, male Jewish citizens, essentially are enfranchised just like any other male citizens who are allowed to vote. And by the franchise is interesting because in a number of states, free blacks are allowed to vote, although not in any of the Deep South states except North Carolina. So you have fairly open voting, provided you own enough property and you meet the other qualifications for voting. However, for office holding, it's very different. And of the 11 states that write constitutions, Rhode Island and Connecticut do not. But of the 11 states that write constitutions, 9 of them specifically say that in order to hold office, you must either be a Protestant or a Christian. One of the oddities, Delaware says you have to be a Trinitarian. I guess they don't like Unitarians for some reason in Delaware. But everywhere else you either have to be a Protestant or a Christian. Of course, the difference would be that Catholics could hold public office where you have to be a Christian, whereas they could not where you have to be a Protestant. Jews, in other words, are prohibited from holding public office in 9 of the states. Rhode Island and Connecticut also continue their old colonial rules against Jewish office holding. The only place where Jews are allowed to hold public office then are in New York, which explicitly has no provision on religious requirements for office holding, and Virginia, which sort of evades the issue altogether. There is by this time a small Jewish community in Richmond. By the turn of the century, by 1800, Jews are very well integrated into American society. During the Revolution, a lieutenant colonel named Franks had served on Washington's personal staff. This is, I am fairly certain, the first officer of an army in the Western world ever. There had been Jewish officers in Poland, there had been Jewish officers in Eastern Europe, but none of the Western countries, Holland, France, England, had ever had Jewish officers. Washington has a Jewish officer on his staff, as well as a number of other Jewish officers. From Savannah, Georgia, there is an entire company that is made up of young Jewish men. It's known as the Jews Company from Georgia. There are Jews in the Army, and no one seems to question, no one seems to be concerned about this, even though the states are busy passing constitutions that say Jews can't hold public office. So there's this kind of weird dichotomy of where you sit in relation to public law and in relation to the ability to survive in the society. There's your trivia point for the day. The first graduating class in West Point in 1802 is 50% Jewish. That is, of the two people who graduate West Point, one of them is named Simon M. Levy, and so he graduates number 2 in his class, or he's second in his class, or last in his class, depending upon how you want to look at it. By 1810, Mordecai Noah, who was a very successful politician in New York, had been the sheriff of New York, which again is Jews moving into the legal world. At the same time, you begin to get Jews showing up in litigation. And here's where Jews in the law becomes more problematic. In 1793, the Pennsylvania Supreme Court, sitting for a jury trial, which Supreme Courts did in those days. Here's the case of Stansbury v. Marks. And Marks calls as his witness Jonas Phillips. Jonas Phillips says that he will not testify at this case because the trial is being held on Saturday and it is against his religious faith to testify on Saturday. And therefore he is fined £10, which is a significant amount of money, for refusing to be a witness. His argument is, it's my Sabbath, you can't make me testify on my Sabbath. The Pennsylvania court thinks this is irrelevant. Fortunately for Mr. Phillips, the defendant, Mr. Marks, waives his testimony, and therefore Phillips is discharged from his fine. So that's 1793. In 1831, we have another case before the Pennsylvania Supreme Court. This time the case is Phillips Executors versus Gratz et al., administrators. And this is a fight over the estate of a very wealthy Jewish family. The Gratzes are fighting the Phillipses. By the way, these families are all intermarried and all tied together. They are the elite of the American Jewish community. And in the process of this case, the question comes up whether or not Phillips, who is the plaintiff, is entitled to a new trial because he refuses to appear at the trial because the trial is held on Saturday. So again, what we have is the question of, can you hold trials on Saturday? May you compel Jews to be at the trial? May you punish Jews if they are not at the trial? The court rules that Phillips is not being forced to disobey his religious beliefs. He simply has to decide whether he wants to show up in court or not. That's his privilege, but that this does not violate religious freedom because nobody is requiring him to become a Christian. Nobody is requiring him to, in a sense, violate his religious values. He simply can't claim that he's entitled to a continuance merely because of his religious beliefs. And the Chief Justice Gibson, who writes the opinion in Pennsylvania, says, "It has never been held except in a single instance that the course of justice may be obstructed by scruple or obligation whatever. The sacrifice that ensues from an opposition of conscientious objection to the performance of a civil duty ought, one would think, to be part of him whose moral or religious idiosyncrasies makes it necessary. So it's interesting, Jews, because they worship on Saturday, have religious idiosyncrasies, and therefore they're not entitled to protection. The arguments in the case are fascinating because the attorney for Gratz makes the argument that if we concede this, then we'll never be able to have trials because there'll always be people who want some exemption or another exemption. The argument goes nowhere. Phillips's lawyer argues that a matter of conscience, which, quote, no human authority can in any case whatever control or interfere with, and that no preference shall be given by law to any religious establishment or modes of worship, as the Pennsylvania Constitution requires, means that Phillips should get an exemption and get a retrial, not on Saturday. The court simply doesn't buy it. The court says that having your religious conscience protected does not go to regulating the court. And so Mr. Phillips loses. This basically is the state of the law on the eve of the American Civil War. Jews hold public office. There have been Jewish members of Congress. There have been 2 Jews in the U.S. Senate. Anybody, trivia question, what state is the first Jewish U.S. senator from? This is before the Civil War. What was that? Florida. There is a Jewish senator from Florida who is the first senator from Florida who's Jewish, and then the more important one is Judah P. Benjamin, who was elected from Louisiana, who later goes on to be the Secretary of State for the Confederacy. So you have 2 Jewish senators, you have a number of Jewish congressmen, you have Jews who are mayors. Maryland, by the way, had prohibited Jews from holding public office until the 1820s, and twice the people of Maryland, Baltimore, wanted to elect a Jewish mayor, but the law wouldn't allow them. Finally, Maryland passed something called the Jew Bill, and that's what it's done as, the Jew Bill, and the Jew Bill says that Jews can hold public office. North Carolina, during this period, refuses to allow Jews to hold public office under its constitution, which, by the way, is not changed until 1868. However, when Jews are elected to the North Carolina legislature, the legislature rules that this is not a public office because this is an office in the hands of the people, and the people can elect anybody they want. So what the legislature rules is that the constitutional prohibition on Jews holding office only would apply to appointed office or maybe the governor, but not the legislature. So this is the state of affairs when the Jews... when the American Civil War breaks out. Now, the American Civil War is, of course, notorious in the history of Jews and the law because of the order of General Ulysses Grant. Ulysses Grant issues an order in December 1862 which says, the Jews as a class violating every regulation of trade established by the Treasury Department and also department orders are hereby expelled from the department, which was known as the Department of the Tennessee, an administrative district of the Union Army, which basically consisted of Kentucky and southern Illinois. And so Grant tries to expel the Jews from his region. There is a decent-sized Jewish community in Paducah, Kentucky. There's a decent-sized Jewish community in southern Illinois. These Jews are being expelled, and they are deeply concerned. Some of them are rushed out of town without a chance to do anything more than lock the door on their house. But immediately, a group of Jews from Illinois travel to Washington, D.C. to see their friend, the former Illinois politician Abraham Lincoln. Abraham Lincoln immediately, when he finds out about this, contacts the Secretary of War, who contacts General Grant and advises him that he will rescind this order immediately, and it is rescinded. This is the only instance in the entire history of the United States that you have an official federal policy of anti-Semitism. And it lasts for all of about 2 weeks, and it is over. It is also possible that Grant just wrote it because somebody said, gee, you know, all these Jews are, you know, trading cotton. Grant said, get rid of the Jews. There's no evidence that Grant ever shows any anti-Semitism later in life. And while it's a cliche to say some of my best friends are Jewish, in the case of President Grant and ex-President Grant, one of his best friends was Jewish, one of the Seligmans, who was one of his favorite poker partners. And Grant shows no anti-Semitism in any other way. He doesn't discriminate against Jewish military officers in any way. So it's kind of like a weird aberration, and it simply happened. But the other side of the Civil War history is much more interesting. Jefferson Davis chooses Judah P. Benjamin to be in his cabinet. Benjamin ultimately holds three different positions as a cabinet member. Lincoln appoints a Jew to be the military governor of Louisiana after Louisiana is back under United States control. There are a number of Jewish field officers. There are a couple of Jewish generals in the United States Army. Jews fight on both sides of the war. And most interesting of all is a debate in Congress over military chaplains. Because since the beginning of the United States, there, of course, had been military chaplains. The chaplain law says that only somebody who is ordained as a Protestant minister can be a chaplain. The chaplain law also says that each regiment is allowed to choose its own chaplain. Well, there's a regiment out of Illinois that has a significant number of Jewish members, and this regiment chooses a Jewish chaplain. And there's a great crisis. Do you allow a Jew to be a chaplain? On one hand, the regiment can choose its chaplain. On the other hand, that chaplain has to be a Protestant minister. And eventually it's resolved by Lincoln intervening with Congress, gets Congress to pass a law which allows Jews to be chaplains. So for the first time, you have Jewish military chaplains during the Civil War. Now, Benjamin is offered a place on the Supreme Court. Judah P. Benjamin is a brilliant lawyer. Unlike, by the way, the first Jewish senator, David Yulee, who was originally David Levy. So the guy who said Levy is half right. David Levy changed his name to David Yulee because Mr. Yulee was going to die childless, and Yulee said, "If you'll take my name, I'll make you my heir." So Senator Yulee said, sure, why not? But he's kind of obscure, although he does become a Confederate official. But Benjamin turns down a seat on the U.S. Supreme Court because he's not interested in being disconnected from politics. During the Fillmore administration, there is an example of not official anti-Semitism like Grant, but again, another example of where the government simply is uninterested in questions involving Jews. Fillmore negotiates a trade and commercial treaty with Switzerland. And under this trade and commercial treaty with Switzerland, Americans are allowed to buy real estate in Switzerland, and the Swiss are allowed to buy real estate in the United States, and Americans are allowed to practice their business and their trade in Switzerland, and the Swiss are allowed to do the same here. However, in the treaty, the Swiss say Americans may do this except as limited by cantonal law. Now, Switzerland doesn't have states, it has cantons, all right? And each of these cantons is extremely independent. The Swiss Federation is much less national even than the United States. And about half the Swiss cantons prohibit Jews from living in the cantons or buying land or engaging in certain kinds of professions. And so when this treaty comes before the Senate, Fillmore, through Secretary of State Daniel Webster, offer up the treaty and say there can be no objections to this treaty. This is a terrific treaty for Americans. And immediately Jews complain that, no, this is a horrible treaty because Jews will be treated different than other people. And it takes 4 more years for the treaty to be ratified because of arguments with Switzerland about how to deal with the Jewish issue. Ultimately, it is not really resolved. Ultimately, the treaty is signed, and the treaty still allows for local discrimination, but not quite as much as there would otherwise have been. So this is, I think, fairly standard for American law at the time. So let me move on to the Supreme Court, because I had initially thought that I would just talk about the Supreme Court, and I proposed the topic, my title would have been, is the Supreme Court a friend of the Jews? And so we can title this section of today's CLE, is the Supreme Court a friend of the Jews? In order to answer that question, in order to think about question, we have to think about ways in which the court hears cases that may involve Jews as Jews or Jewish practice as Jewish practice, as opposed to plaintiffs or defendants who simply happen to be Jewish, or as opposed to lawyers who simply happen to be Jewish who are representing people. And it's clear that a significant number of very successful appellate lawyers who have Supreme Court practices have been Jewish, particularly in the 20th century. And of course, it is also clear that at various times there have been very significant justices who are Jewish, starting, of course, with Louis Brandeis. And now we have the oddity, the peculiarity, the weirdness, I would argue, of a Supreme Court that has 3 Jews on it and 6 Catholics. It is the most unrepresentative Supreme Court in the history of the United States. It represents nothing that would resemble the United States. We do have, of course, a justice from Manhattan, from Queens, from the Bronx, and from Brooklyn. I don't know what they have against Staten Island, but we have a justice from New Jersey, and perhaps Justice Alito actually also represents Staten Island. Justice Roberts, of course, was born in Buffalo. So we have a court that is essentially a northeastern court. Justice Breyer, while he grew up in San Francisco, spent his whole adult life in Boston. So we have a very weird Supreme Court simply in the way of it is structured and who sits on the court, and religiously it is also very weird as well. But what I want to look at are cases that involve people because they are Jewish or because of their Jewish practice. And the first important one is Frank v. Mangrum, which is heard in 1915. The Frank is Leo Frank. Leo Frank is a Jewish businessman living in Atlanta who is accused of raping and murdering a young white Christian girl who works in his factory. He denies that it ever took place. Recently, in the last 10 years, evidence has come to light that shows that, in fact, he did not do this, which many people believed at the time. Nevertheless, in an atmosphere of extreme anti-Semitism, Frank is accused, tried, convicted in what can only be described as a circus trial, sentenced to life in prison, and he appeals to the Supreme Court, arguing that he has been denied due process of law, that he has been denied a fair trial because of the extreme circumstances surrounding his trial. The Supreme Court is not interested. Now, the court is hiding behind its procedural notions of it can't interfere with state courts, that the 14th Amendment due process clause only goes to the procedural due process and nothing beyond that. This is a court, remember, that has had no problem striking down very popular state legislation like the wage and hour regulations, famously, of course, the Lochner case. This is a court that has struck down child labor laws and will continue to strike down child labor laws. This is a court that is perhaps the most activist court in American history in striking down all kinds of progressive legislation. But when it comes to Leo Frank's case, the court sees nothing wrong with the case. Frank is sent back to jail, and then shortly after that, a mob breaks into the prison and lynches him. So that's the kind of first Jewish case we get. And I call it a Jewish case because really Frank's argument is that he is denied a fair trial because he is Jewish, because of the anti-Semitism that exists in Atlanta at the time. The next case is not exactly a Jewish case because it involves Jehovah's Witnesses, but it is tied to Judaism in a variety of ways, and that is these are the flag salute cases. In 1940, the Supreme Court hears a case known as Gobaitis, and in the Gobaitis case, 2 children have been suspended and then expelled from a Pennsylvania public school for refusing to salute the flag in violation of their religious beliefs as Jehovah's Witnesses. The Supreme Court, in an 8-1 decision written by Justice Felix Frankfurter, upholds the prosecution. And Frankfurter, in his opinion, says that patriotism is an important value, that saluting the flag is an important aspect of patriotism, and that we must have the cohesion of flag salutes to create a patriotic citizenry. Now, of course, Frankfurter is looking at World War II, which is being fought in Europe, and he's seeing the flag salute as very important. And he quotes Lincoln in his opinion, saying that Lincoln talked about facing the great dilemma of, do I violate one small clause of the Constitution to protect the whole Constitution? And Frankfurter says that if we are indeed impinging on their religious freedom, we may have to do this to save the Constitution itself. 3 years later, in West Virginia Board of Education versus Barnett, the court reverses these decisions in an opinion written by Justice Robert Jackson, who will later go on to be the chief prosecutor at Nuremberg. And Jackson writes what is perhaps one of the 2 or 3 most eloquent opinions in Supreme Court history, in arguing that the Barnett children have a right not to salute the flag because it would be a violation of their free speech rights to force them to salute the flag, and that this goes to the very heart of civil liberties in the United States. And he goes on to say that he does not think that President Lincoln would be much impressed with the notion that in order to save the Union, you have to jail people who won't salute the flag. He says Lincoln's memorable dilemma of choosing between civil liberties and maintaining a free society, Jackson said, such oversimplification, so handy in political debate, has no place in a Supreme Court opinion. And then he goes on to say that he doubted whether Mr. Lincoln would have thought that the strength of the government to maintain itself would be impressively vindicated by our confirming power of the state to expel a handful of children from school. Frankfurter is livid and writes a long dissent in which he begins with the following sentences. One who belongs to the most vilified and persecuted minority in history is not likely to be insensible to the freedoms guaranteed by our Constitution. Were my purely personal attitude relevant, I should wholeheartedly associate myself with the general libertarian views of the court's opinion. And then he goes on to say that it is okay to persecute Jehovah's Witnesses at precisely the time that his own relatives are being carted off to concentration camps and death camps in Europe. And what's fascinating about this is the origin of the Jehovah's Witness refusal to salute the flag came about in Germany in the 1930s when Jehovah's Witnesses refused to go like this to the Nazi flag, saying that this is a form of idolatry. and saluting a flag is bowing down to an idol, and we will not do it. And the American Jehovah's Witnesses stopped saluting the American flag in sympathy to their German Jehovah's Witness co-religionists who were the first to go to camps ahead of the Jews in Germany. They got the Jehovah's Witnesses and they got the commies first. And so Frankfurter says, as a member of this oppressed minority, I'm not insensible to civil liberties. He clearly is. He just doesn't get it. And from the perspective of Jews in the Supreme Court, what we see is this Jewish Supreme Court justice, this refugee from Europe, who simply doesn't get the connection. This becomes more apparent in the Sunday closing laws. Now, Sunday closing laws are very early. As early as 1660, Abraham de la Serna, a Jewish merchant in the New Netherland colony, is fined for selling goods from his store while the Sunday sermon was being preached at the local Dutch Reformed church. Now, what's interesting, of course, is apparently all the local Dutch Reformed weren't in church. They were busy buying things at Lucerna's store. But that's the earliest example we have of a prosecution for violation of Sunday closing laws. Sunday closing laws exist in various states at various times. And again, in the early 19th century, there are a couple of Pennsylvania cases in which Jews are prosecuted for opening their businesses on Sundays, always arguing that they can't stay closed 2 days a week and they have to close on Saturday. The courts always say, too bad. This issue reaches the U.S. Supreme Court in 4 cases in 1961 involving Sunday closing. One of the more important ones and more of the obvious ones is Gallagher versus Crown Kosher. Doesn't take a genius to figure out what the case is all about. Crown Kosher is a kosher butcher and grocery store that is open on Sunday and is closed on Saturday. Now, the argument against Sunday openings for Jews is that it gives them an unfair business advantage, because if they close on Saturday and open on Sunday, they're the only people open on Sunday and they're going to get all the Sunday business. If you are the only hardware store open on Sunday, you're going to do a lot of business, while your Christian neighbors will have to divide all the Saturday business and you'll get all the Sunday business to yourself. So that's part of the argument. However, this argument is deeply implausible when you are dealing with Crown Kosher for a couple of reasons. First of all, Crown Kosher cannot be open on Saturday. You can't, and by the way, the justices suggest that these other stores could be open on Saturday. The Jew just doesn't have to go to the business. I guess you could have a Shabbos Goy, as they used to call them, run your store on Saturday. Or you could be a law firm like Cleary Gottlieb, and so you can have the Jewish guys who come through Gottlieb who are going to take off Saturday, and the Catholic guys coming through Cleary would take off Sunday, and everything will be fine. But Crown Kosher is different because it wouldn't be kosher if it was open on Saturday. You have to be Shomar Shabbat. You have to observe the Sabbath to run a kosher business. So the Commonwealth of Massachusetts prosecutes Crown Kosher and wins. The other argument, which was not made in the case, but it ought to have been, is that by forcing Crown Kosher to not open on Saturday, it is harming the customers in a very significant way. Because if you are somebody who works during the day, you can't go to the grocery store except at night, and the grocery store may be closed. You can't go on Saturday, and now you can't go on Sunday. So you have a very limited opportunity of when you can go and buy the very food you need to survive through your faith. So Crown Kosher loses, as do all of the other Sunday closing cases. And in dissent, Justice Potter Stewart declares that a Pennsylvania law, which was from one of the other cases, Braunfield versus Brown, Either that or it was from two guys from Harrison. There are a bunch of these cases all at once. But Justice Potter Stewart says the law grossly violated the Free Exercise Clause by offering an Orthodox Jew, and I quote from Justice Stewart, a cruel choice between his religious faith and his economic survival. Because if you're forced to close your retail business on Saturday and on Sunday, your economic survival is at stake. Now, that's the dissent. Justice Frankfurter concurs with the majority opinion and writes a 100-page appendix in which he researches every single Sunday closing law in the history of the United States to show beyond a doubt that Sunday closing is part of a long American tradition. And one can only wonder, as a member of a long persecuted minority, why he felt the necessity of spending hours and hours of his own time and his clerk's time to do all this research to prove that persecuting Orthodox Jews was a legitimate thing to do under the Free Exercise Clause of the Constitution. And so the Sunday closing laws stand for the proposition essentially that it's okay to persecute Jews as long as you don't call it that, and Justice Frankfurter leads the charge. It is really, again, in a Supreme Court career of a significant number of embarrassments, I think that this concurrence may be the worst after his opening paragraph in his dissent in West Virginia versus Barnett. In 1986, the court hears Goldman versus Weinberger. Goldman is a U.S. Air Force captain, a PhD psychologist who works for the Air Force as a psychologist. He is preparing to make a career in the Air Force. He has just his re-upping within the Air Force has just been approved. He is on his way to being a lieutenant colonel. And he sits in his office all day long and does psychological counseling on an Air Force base. And he wears his uniform every day, and underneath his official Air Force hat, he, of course, has a small yarmulke because he is an Orthodox Jew. No one in the Air Force base has ever complained about him wearing the yarmulke, even though many other officers see him wearing a yarmulke in his office all the time. As the majority opinion concedes, he avoided controversy by remaining close to his duty station in the health clinic and by wearing his service cap over the yarmulke when out of doors, as, by the way, he was required to do, which is to wear a service cap. But in April 1981, he is asked to testify in a court-martial, and he's asked to testify for the defense. And this is a wonderful example of legal ethics here, okay? And the legal ethics question is for the prosecutor. Captain Goldman walks in, he takes his service cap off because he can't wear it indoors, starts to testify, and immediately the prosecutor objects to his testimony and furthermore immediately charges him with a violation of his Air Force rules because he is out of uniform. Why? Because he's wearing a yarmulke. His testimony is excluded, and instead he is prosecuted and cashiered from the Air Force. There is, by the way, an Air Force regulation which allows a base commander the right to offer exemptions to certain uniform rules for particularly compelling reasons. The Air Force commander could easily have simply said, Goldman can wear the yarmulke, get on with the trial. This does not happen. So the question before the Supreme Court is whether or not the desirability of dress regulations in the military should be decided by the appropriate military officials and whether they are under a constitutional mandate to abandon their consideration, their considered professional judgment. This is how Chief Justice Rehnquist frames the case. Not surprisingly, Chief Justice Rehnquist finds that the right of the military to dictate how uniforms should be worn surpasses the First Amendment, and Captain Goldman loses his case. In the argument of the government, the government says that While a yarmulke may not seem obtrusive to a Jew, neither does a turban to a Sikh, a saffron robe to a follower of the yogi, nor do dreadlocks to Rastafarians. But as Justice Brennan points in dissent, turbans, saffron robes, and dreadlocks are not before us in this case. And that we should not go off into these fantasy lands. I know of no Rastafarians who were volunteering for the all-volunteer army in the 1980s. So this is the debate as it's framed. The dissenters point out that the military is not going to collapse on the basis of this. One of the dissents notes that while the government makes a great argument about unit cohesion and everybody looking alike and everybody thinking alike, the reality is that in the military there are many people who are in fact wearing religious garb all the time, and this religious garb is obvious to everybody in the military. The dissent points out, for example, that Christians wear crosses, that Mormons wear their religious garments underneath their clothing. In the barracks, you see all sorts of things, and the yarmulke isn't going to harm anybody. The Supreme Court doesn't buy it, and so the Jews lose before the Supreme Court. By the way, the footnote to this, and in law schools, of course, they never teach you the footnotes because they only want you to learn the legal principle. But the legal principle that's important for all of us, both as legal practitioners and as citizens, is the Supreme Court does not get the last word most of the time. 2 years later, Congress creates blue yarmulkes for the Navy, blue yarmulke, different shade of blue for the Air Force, green for the Army, and I guess a different shade of green for the Marines. And so now if you are in the service and you are Orthodox, you can get your official Army, Navy, Air Force, Marine yarmulke and wear it as part of your uniform. And the American Army has not collapsed as a result of this. But the Supreme Court did not see it that way. Let me give you a couple of more examples of this. One example has been the debate over Ten Commandments monuments. A few years ago in Van Orden versus Perry, the Supreme Court upheld a Ten Commandments monument on the Capitol grounds of the state capitol in Austin, Texas, and the argument was that sort of everybody believes in the Ten Commandments. The Ten Commandments are unobtrusive. But in fact, all of these Ten Commandment monuments use a decidedly Protestant version of the Ten Commandments. The one in Texas happened to be a Lutheran Ten Commandments. By the way, the Lutheran Ten Commandments is different from the mainstream Protestant Ten Commandments, which is different from the Catholic Ten Commandments, which is different than the Jewish Ten Commandments. All four of these faiths have a different Ten Commandments. The structure and numbering of the Ten Commandments are different, and of course so too is the translation. I once gave a talk about this in Oklahoma, and I talked about the problem of translating, and somebody raised their hand and said, I don't want to hear about any foreign translations of the Bible. And I sort of thought, well, that'd be fine, you know, we could just, you know, put it up there in the Hebrew. So these are significant issues, but how you translate the Ten Commandments, how you put the Ten Commandments up on a monument, determines what faith you are in and what faith you are following. And the court simply is stone deaf to this, or at least a majority of the court, 5 justices. And by the way, what was the deciding justice in Van Orden versus Perry? Justice Breyer, the Jewish justice from Boston, who's a member of an Episcopal church, but nevertheless, or at least was before he was nominated to the court. Justice Breyer switches his vote. There were 2 companion cases. He votes to strike down a new Ten Commandments ordinance in Kentucky and votes to uphold Van Orden versus Perry. And Breyer says, well, this isn't really a problem. Breyer's opinion, quite frankly, I think is intellectually dishonest because he asserts facts which he knows from the briefs are simply not the case. And so again, what we have is the court ignoring what is essentially a Jewish question or a Jewish issue for a larger kind of pan-Christian issue. Now, what I find interesting is that none of the Catholics on the court were upset by the fact that this was a Lutheran Ten Commandments rather than a Catholic Ten Commandments. But be that as it may, clearly for Jews who visit the state capitol, for Jews who visit the many courthouses with the Ten Commandments, they see the Ten Commandments, and the first question they ask is that's wrong, or why did the rabbi teach us that's wrong? And you can only imagine where that gets them if they're with the third grade class. Another issue that is similar, of course, is the issue of public prayer. Now, the court has struck down prayer in public schools in a variety of ways, and these cases are old. I'm not sure if they would hold up today. I just don't know where this court would go. But certainly in the last term, the court upheld the right of the town of Greece, which is suburban Rochester, New York, to begin its city council meetings with a prayer. And the record showed that with two exceptions, in the entire history of the city council, the prayer had always been given by an evangelical Protestant minister and always closed with, "We pray in the name of the Lord Jesus Christ." Now, the plaintiffs in this case argued that this was in fact a government imposition because, as any of you who've ever gone to a local government to get relief for your client, local governments are very close in. It's not like the prayer for the Supreme Court, "God save this honorable court." This is a prayer being invoked while you are down there hoping that you're going to get relief from the city council. And I can only imagine how somebody wearing a yarmulke or a Hasidic Jew is going to feel when the proceedings begin with "in the name of the Lord Jesus Christ," and they're thinking, well, what chance do I have of convincing this city council that I'm going to get relief? By the way, the city argued that they had not asked rabbis to speak because there were no synagogues in the town of Greece. Now, that's entirely true. The town of Greece is a relatively small town in suburban Rochester. There are Jews in the town of Greece, but the synagogue is in the next town or two towns over. They're in the town of Brighton, not the town of Greece. So the argument was we only ask people within our town to speak at our town meeting. And the court, again, upholds this 5-4 with Justice Kagan, to her credit, writing a spectacularly good dissent. I should add the first footnote in Justice Kagan's dissent is to an amicus brief submitted on my behalf. So I thank her very much for citing me in her opinion. So I'm going to end with this section on the Supreme Court and turn to a slightly different topic, which is going to take us into New Jersey. In fact, what I want to talk about right now is keeping kosher. And I want to talk about kosher law and civil law. In 1813, there was a fight within the board of Sarah Yisrael, the synagogue in New York City, and they fired their shochet, Jacob Abrams, who had been the shochet for 10 years. There were complaints about him in various ways, although I don't know exactly what the complaints were, whether he had his thumb on the scale or what. But in any event, and they hired a new shochet. And Abrams, however, then continued to sell kosher meat and butcher his own meat and sell it as kosher. And the trustees of the synagogue went to the New York City Common Council and got the Common Council to pass a law saying that only their congregation would have the right to sell kosher meat in New York City. They would be the only one who could assert that something was kosher. And so that law passed, and then immediately friends of Jacob Abrams, I guess there weren't complaints by everybody, went to the Common Council and said this was denying them their religious liberty of being able to buy kosher meat from whoever they wanted, as well as denying him his religious liberty. And the result was that the law was then revoked, and that was the end of kosher regulation in New York City for a while. In 1915, the state of New York passed the kosher bill, not to be confused with the Jew bill of Maryland. And the kosher bill made it a misdemeanor to, quote, falsely represent meat for sale as kosher if it was not kosher. And agencies regulating consumer fraud in New York City at the height of the progressive movement of New York begin to investigate kosher butchers. In 1916, 57 butchers were prosecuted for selling treifa meat. At the time, there were 6,000 butchers in New York City. It's estimated that 3,600 of them sold kosher and non-kosher meat at the same time, therefore, of course, creating the possibility of fraud. The Kosher Butchers Retail Association in 1910 claimed that 65% of all the, quote, kosher butchers in New York City were selling unkosher meat. This leads to more inspections, and what you have is a staff of New York City inspectors inspecting for kosher violations. Many of these inspectors were not Jewish, nor were they trained at yeshiva or anywhere else to know how to inspect for kosher. In 1922 and 26, stronger laws are passed. In 1923, Mayor John Hyland assigns enforcement to the Department of Marketing, which in 1926 creates, and I love this, this may be my favorite phrase of all of American legal history, they create the kosher squad. And the kosher squad runs around the Elliot Ness of the kosher squad. And the kosher squad goes around New York City looking for unkosher meat. A Yiddish paper calls the New York City DA, quote, the best chief rabbi New York ever had. In 1925, it's estimated that 40% of the kosher meat sold in the state was in fact treif, and there are charges of corruption and bribery and extortion by kosher inspectors, as we would expect. That is, the kosher squad was in fact taking money under the table. They were not all that kosher themselves. By 1992, 21 states have kosher fraud laws, including, and I love this, Louisiana and Texas, each of which has a Jewish population of less than 1% of the entire state. I'm not sure that there's a kosher butcher in Kentucky. I think there's one in New Orleans, but they have kosher fraud laws. The New York law of 1915 defined kosher as, quote, prepared under and consisting of products sanctioned by the Code of Jewish Laws, namely the Shulchan Aruch, which of course was written, the Maryland kosher law, it's not the New York kosher law, says sanctioned by the Code of Jewish Law, namely the Shulchan Aruch, which of course was written in 1563 and published in Italy in Hebrew. So here we have Maryland in the 1920s essentially incorporating the Code of Jewish Laws into the law books of Maryland. In 1925, the Supreme Court upholds New York's kosher fraud laws in high-grade provision company versus Sherman, but this is done on the grounds that the law is not a violation of due process. In 1925, the First Amendment had not been incorporated to the states, and so there's no religious freedom or establishment clause issue. It's merely a due process issue. And all this gets us to 1992 and the wonderful case of Ron Dov's County Kosher versus the state of New Jersey. And how many of you know this case? Just a couple of, okay. Well, the Ron Dov case is really interesting. Ron Dov's County Kosher is a kosher butcher, and Ron Dov uses a rabbi from New York City, and this is the backstory. This is not in the opinion, but this is the backstory. And the local kosher inspector, by the way, New Jersey has a kosher inspection board, which consists of 10 rabbis, 9 of whom are Orthodox and 1 of whom is conservative. So you have a New Jersey statute which requires that only rabbis and only rabbis of a certain flavor of Judaism may be hired by the state of New Jersey to do something. This would be very different than, say, the notion that at the state penitentiary you have to have a rabbi as a chaplain. And by the way, in the military, chaplains are trained to perform religious ceremonies for all faiths. That is, if you are a rabbi working on a military base, you have to know how to do last rites for Catholics. You have to be able to do absolution and confession for dying Catholics. You have to be able to perform a Protestant wedding. You have to do all these things if you are the only chaplain on the base. If it's a big enough base to have multiple chaplains, that's a different story. So, but New Jersey has this law which says only rabbis can be hired. Now the question is, what's the politics of this? One of the allegations against Ron Dov, for which, by the way, under the New Jersey kosher fraud statute, if you sell something which is falsely representing to be kosher, you could be fined between $2,000 or $5,000, depending on whether it's a first or second offense. So Ron Dov is facing a $5,000 fine. One of the allegations against him is that in his freezer he has frozen chicken, which is from a producer which had been declared to be not kosher. And in fact, that was true. He didn't deny it. He had received a shipment of goods from a kosher producer, and the next day he got a fax saying that that meat is not kosher and that he should not sell it, and that if he will simply keep it in his freezer, they will send a truck to pick it up. So he wraps it up and puts it in the bottom of his freezer, and in pops the kosher inspector and says, "Aha, you have unkosher food." And he says, "Yeah, which is why it's wrapped up in the bottom of the freezer, and I'm not selling it." And they said, well, having unkosher food means you're in violation because this is going to be fraud. You're going to sell this. So there's a lot of politics involved in this case. And so the case goes to the New Jersey Supreme Court. And the New Jersey Supreme Court does a terrific job. This is Justice Handler. I'm assuming Justice Handler is Jewish. Is that correct? Along with, it's an interesting case because of the 4 majority justices, 3 of them are Jewish, and in dissent, there's 1 Jew. So Justice Handler does, I think, a very good job of pointing out the enormous complexity of the rules of kashrut and trying to figure out what is kosher and what is not kosher. And even the state concedes that there are, in fact, distinctions and differences among Jews as to what would constitute kosher and what would not. The easiest example is Sephardi eat rice on Passover, Ashkenazi do not. So if you were a kosher butcher and you were selling rice on Passover, could the Ashkenazi Kosher Board of New Jersey close you down for not being kosher? These are, they could. Well, but they could, you see, and then you'd have to debate it. Because this is why the New Jersey Supreme Court declares that this law is unconstitutional. Because basically what the New Jersey Supreme Court rules is, after a very long and careful opinion, is that the state of New Jersey cannot get in the business of deciding what is kosher and what is not kosher. And the state of New Jersey cannot hire the committee, the chief of the Bureau of Kosher Enforcement. They can't have a Bureau of Kosher Enforcement. They can't get involved in determining what's kosher and what is not kosher, that it violates all of the constitutional standards surrounding separation of church and state. It is a clear entanglement issue, and so New Jersey's kosher fraud law is struck down. As far as I know, other kosher fraud laws have not been struck down, but they have been, I'm not sure anybody's trying to enforce them any longer. Yes. In any event, so that's the Randov case. And in fact, there are some solutions to this. One solution is to leave kashrut entirely to the free market. That is to say that if you say something's kosher, it's up to you, the consumer, to determine whether or not it's kosher. That is, you can look for the OU, which is the Union of Orthodox Rabbis. You can look for the kosher K. You can look for a hechsher from a rabbi. I buy wine from France and Spain, and occasionally it has on the back that this wine is kosher for Passover, and it's all in Hebrew and French, and it's done by the chief rabbi of France. And and as long as his name is Rothschild, I'm happy to drink the wine. So that's one possibility. And by the way, that's what's worked in most of the United States and most of the world for most of history. It's not government regulation. I have a cousin who's very Orthodox who was once planning a picnic for her shul, and she was complaining about the cost of hot dogs. And I said, I don't know, Hebrew Nationals are on sale for, such and such. And she said, oh, I don't trust the rabbis at Hebrew National. And so, I looked at her and I said, well, you could polygraph them. I mean, the point is that she went to the butcher that she trusted. So that's one possible way of doing it. The other way, of course, in addition to that, you would, of course, vigorously enforce fraud laws where somebody puts a hechsher on that isn't in fact legitimate. So if you put an OU on your food and it's not in fact been approved, then you're in violation of fraud. And that's simple fraud because that doesn't require that the state determine whether the food is kosher. That only requires the state to determine whether or not the kosher authority has asserted that it's kosher. And what I think the state cannot do is get behind the kosher authority. They can't get behind Ron Dobbs' rabbi. All they can do is say, did Ron Dobbs' rabbi from New York approve this? Yes, you're free to buy or not buy, whether you trust Ron Dobbs' rabbi. The other way of doing it is to follow what is a New York statute of 1982 known as the Torah Merchant Statute, which is part of the New York General Business Law, Article 39A. Okay, and the Torah Merchant Statute requires that somebody who sells a Torah disclose the source of the Torah, any identifying marks, and the authority that the merchant has to sell this particular Torah. By the way, the law describes the Torah as an edition of the Pentateuch handwritten on parchment. When I was preparing for this talk, I was thinking, well, if I got some parchment and wrote out a Torah in English, would it be a Torah? Because it would be my edition of the Pentateuch, handwritten on parchment. But then I would have to determine what my authority was to sell said Torah. So the Torah Merchant's Law, again, does not go to whether the Torah is a kosher Torah. It only goes to whether the merchant has gotten a checklist. And so by this issue, and I think that's in effect what New Jersey can be doing with kosher fraud. Let me give you one more example of this. The New York General Business Law 1988 also has a civil penalties for anyone who knowingly sells a mezuzah or tefillin that, quote, does not satisfy Orthodox Hebrew ritual requirements. Now, I really find it interesting that the state of New York in 1988 is using the word Hebrew requirements because most Jews don't call themselves Hebrews any longer, and I suppose Hebrew requirements, I would read this as a grammar issue. That is the scroll inside the Torah, inside the mezuzah, or inside the tefillin, is it grammatically correct Hebrew? Because that would be the Hebrew requirement. But that is not, in fact, what they mean. And again, this is a really fascinating notion because I think this law as written is probably unconstitutional because it requires the state to determine what meets the Hebrew requirements. And again, as a personal example, I was in Israel some years ago, and my rabbi asked me if I could pick up a number of mezuzot for the temple to sell at the gift shop. So I bought a bunch of mezuzot, and the question is, what scroll did I get for inside the mezuzot? Because the person selling me offered me handwritten parchment scrolls, and he also offered me printed paper scrolls. And I could choose which one I wanted. The printed paper scrolls were about 10 cents each. The parchment scrolls were about $10 each. It was, it was a big difference in price. And so the question is one more kosher than the other? Well, if you're Orthodox, one is clearly more kosher than the other. If you're Reform, it's not. So again, the very law, I think, would require the state of New York to get involved in an issue that it probably is not competent to get involved in. The mezuzah law, or the Torah merchant law, is you are being asked to prove ownership, and you are asked to prove, in a sense, a chain of title and a provenance. You are not being asked to prove whether or not it's a legit one. So if I sell a Torah and I say, well, I got it from, the Rebbe Cohen at the Jewish Community Center in Teaneck, then they can decide whether the Rebbe Cohen is good. Somebody's holding up its time sign? No? Oh, I thought so. Okay, all right. We have about another 15 minutes, is that right? Anybody know? 20. Oh, good. Okay, good. Because we have one more topic. We're not done yet. And I've saved the best for last, okay? Well, actually, I've got two more topics. So this is the next to the last. And that is immigration law. We don't normally think about immigration law as being a Jewish issue. But in fact, of course, the laws passed in 1921 and 1924, which severely restricted immigration, had a significant anti-Semitic component to them. The arguments in Congress were about keeping out those people, and one of the arguments for immigration restrictions in 1921 was that during World War I, the Army had given IQ tests to all incoming soldiers, and the person who ran the IQ tests testified before Congress that the IQ tests proved that certain groups of people were so stupid and so impossible to educate that you should not allow them to come into the country. And so the question is, who are the three worst ethnic groups on the IQ tests in 1917? Who are the dumbest people in America in 1917, according to the Army IQ test? Anybody want to hazard a guess? Jews are number one. They're the dumbest. Number two are Italians. And number three are African Americans. Now, the African Americans are all mostly Southern. 90% of blacks live in the South. Most of them have never gone beyond the 5th or 6th grade because most of the states aren't providing even junior highs or high schools for many blacks. So that's understandable. The Jews and Italians are considered the dumbest because they are the most recent immigrants, and therefore they're the ones who have the most trouble taking these IQ tests in English. And so they can't read them, and therefore they can't do very well. So part of the argument is that we should exclude populations because they are inferior populations. Another issue involving immigration ties to European divorces, because for most Jews, there is no civil divorce in Europe. There's only a religious divorce. And so there are a number of immigration cases in which people come to the United States and then send back a get, which is a Jewish religious divorce, to their wife, saying, okay, I'm here in America, don't come, I'm divorcing you. And then they remarry, and then when they try to get their citizenship, they're busted for bigamy on the grounds that they're not legally divorced. And this flows into my last topic, which is the topic of Jewish divorce. And Jewish divorce, of course, is a complicated issue, but I suspect it's one that some of you run into, let me ask, is there anybody here who's run into divorces involving Orthodox Jews and the delivery of a get in your practice? Okay, let me so there'll be something here that's sort of practical for at least two of you, maybe more. Basically, under Jewish law, a divorce can only be initiated by the husband. The husband must give the wife something called a get, G-E-T, so the wife gets a get, as the bad joke always plays it out. A get simply means a document. The two parties must then go before a Jewish religious court known as a Bet Din. The Jewish religious court performs the divorce ceremony. In some cases, the wife is required to walk backwards around the husband 7 times, and they are now divorced. You do not need a get, of course, to remarry in the United States if you have a civil divorce. And you cannot remarry in the United States if you have a Jewish divorce but not a civil divorce. But you may not remarry under Jewish law if you have a civil divorce and you do not have a religious divorce, although some men can remarry but women cannot remarry. And so a woman who has a civil divorce but not a Jewish divorce is known as an aguna. Aguna means a chained person, and she is essentially chained to her ex-husband. So the scenarios work out as following. Orthodox or conservative Jewish couple get married. They get a civil divorce. The wife asks the husband to give her a get so she can remarry, and the husband says, "No, I don't feel like giving you a get." Now, under Jewish law, this woman is still married. Furthermore, under Jewish law, and this is important to understand, adultery takes place only, and this is the only time adultery takes place is when a married woman has sexual relations with somebody who is not her husband. It does not take place if a married man has sexual relations with a woman who is not married and who is also not married to him. So the man in this scenario is free to have relationships with other women, and while it may be immoral, it may be wrong, it is not adultery under Jewish law. Of course, under Old Testament Jewish law, you'd be stoned for adultery. Now, that's not going to happen anymore, but in a tightly knit Orthodox community, a woman who is an aguna essentially is not allowed to date anybody, is not allowed to go out on a date, is not allowed to remarry. If she does remarry, or if she has children, her children are a special category of people known as a mamzer, and a mamzer can only marry another mamzer if the mamzer is going to marry a Jew, and being a mamzer is a real burden in your life. So Orthodox Jewish women who are divorced in a civil divorce, if they do not get a get, are penned in to a very difficult world. Now, Jewish communities have been living with this problem for 2,500 years, more or less. It is a gigantic problem in Israel, where there is no such thing as a civil divorce, and therefore Orthodox men could simply leave their wives and take up with their girlfriend, and they're not committing adultery, and their wife is hung out, she can't get a divorce. Israel has not been able to solve this problem, but Orthodox Jews in the United States have believed that they can solve this problem by turning to state legislatures and courts. So New York led the way with the passage in 1982 of the New York Get Law, as it's known, followed by the amendment to the New York Get Law in 1992. The New York Get Law requires that the moving party of a divorce remove all obstacles that is in the power of the moving party to remove, so that the spouse can remarry. Now, the problem with this is, if the moving party in the divorce is the wife, she can't get a get. So the get law doesn't affect the wife at all. It can only affect if the moving party in a divorce is an Orthodox Jewish man. So if a Jewish man goes to get a civil divorce in New York, he is required to give his wife a get to remove the impediment. Yes. There is this, yes, and I don't want to get into the deep intricacies of Jewish marriage law here because it's way too complicated. But the reality is that in general, the Jewish man is in the driver's seat here. And furthermore, and this is another technicality which Jewish law has not yet gone into. And by the way, I'm not an expert on Jewish law. When I did research on this subject, I've written on this subject. I called three rabbis, Reform, Orthodox, and Conservative, to talk to them. And I had to start the conversation by saying, "This isn't personal. I'm doing research. I need to know about a get." But the other reality is that while it's not being done, there is nothing in Jewish law that prevents a married Jewish man from having a second wife, because the prohibition on polygamy among Jews was issued about 1,100 years ago, and it lasted for 1,000 years. And
still practically enforced.
I understand it's practically enforced, but it's technically...
It's a lot of work for me to be able to do that.
But it's technically possible, is all I'm saying. It is technically... Yeah, okay, so in any event, so this is the issue. Now, what happens... Yeah. 1992 law makes it a little stronger, because the 1992 law allows a judge in a divorce proceeding to deny a husband his right to most of the marital property that he would otherwise be entitled to if he does not give a get. There was a case in 2002, I believe, where a judge in New York fined a husband $500 a week for the rest of his life because he wouldn't give his wife a get, and he suddenly became the hero of the feminist movement. I'm spacing on the name of the judge, but unfortunately, like 3 years later or 5 years later, he went to the slammer for having taken multiple bribes in divorce cases. So I'm not sure his heroic move was generated by anything more than the wife got to him before the husband. And so he was, and a whole bunch of people went to jail as a result of this. But in any event, the traditional issue becomes the wife wants a divorce, the husband says, "Fine, I'll give you a divorce, and by the way, I'll give you a get, but only if you if you give me the house and full custody of the kids and don't want any alimony. Otherwise, no get." And so this becomes the coercive. It's a political and economic coercion on the part of the husband. Now, courts have dealt with get laws in a variety of ways. In 1990, an Illinois court ruled that someone named Kenneth Goldman had to give his wife an Orthodox get. This was a fascinating case, and this is a really good illustration of why secular courts should not get involved in these kinds of cases. The Goldmans had been married by a Reconstructionist rabbi. Reconstructionists do not require a get to get a divorce. They had, however, gone to the local Jewish store and bought a illustrated, colorful ketubah, which they all signed and put on the wall. Now, as some of you may know, a ketubah is written in Aramaic. Is there anybody here who reads Aramaic and understands it? I got one, Two. All right, so we got our Aramaic scholars. 99.999% of the people who sign a ketubah have no idea what they're signing. But in theory, they are signing a contract. The ketubah does say that they will live in accordance with the law of Moses and Israel. And so a non-Jewish judge in Illinois concluded that living according to the law of Moses and Israel was a contract that these people had agreed to, even though none of them could read the contract they signed, and that therefore he had to give her a get because that was part of the law of Israel and Moses. Even the most sympathetic scholars to get laws say that the law of Moses in Israel does not require that he give her a get. So it's a bad ruling under Jewish law as well as under the First Amendment. But one can also imagine, and there are such cases. There was a case in Michigan in which a couple got married. They were Orthodox Jews, and then he decided to leave Judaism altogether, and he converted to Christianity. She naturally sued for a divorce and demanded a get. And he said, I can't give you a get, I'm no longer Jewish. I can't go to a bet din, I won't do this, I can't do this. The issue came up, by the way, when her daughter wanted to marry. And so the question is whether her daughter from a second marriage was a mamzer because she had never gotten a get from her first marriage. And they finally got a rabbi in Israel to conclude that the first marriage, that he had no evidence that the first marriage ever existed. And if you follow through the story, it's a fabulous example of Talmudic thinking. He says there's no ketubah that we can find, therefore there's no marriage. The only witness to the marriage that we can find is the wife, and she can't testify, the mother of the daughter, and she can't testify because she's an interested party. The alleged ex-husband refuses to talk to us, and we did find the rabbi who married them, but without a ketubah or the other witnesses, we can't prove that he married him, therefore we can't prove that there was a marriage. These are the issues. Well, so this is the question of the day in part for how you deal with these issues. Should the Jewish community be going to the legislature of New York or the courts of Illinois to try and solve a problem which is inherently and essentially an internally Jewish problem? Which is, what do you do with the ex-wife under civil law who cannot get a get? Now, the argument would be, if there weren't civil divorce, we wouldn't have this problem. If there were only Jewish divorce, in other words, if we could go back to the shtetl in Poland, if we could go back to the Prague ghetto, where we had complete autonomy over law, then we could solve the divorce problem easier because there wouldn't be a civil divorce. But because the state gives us a civil divorce, the state creates the problem of the aguna. And without the state giving us a civil divorce, we wouldn't have that problem. The only problem with that is in Israel, you've got 100 times as many women who are aguna, and there's no civil divorce in Israel. My argument would be that the state of New York or the courts of Illinois simply have no business whatsoever trying to figure out Jewish divorce law. Now, there are solutions to the problem. One solution is what's known as the Lieberman Agreement, which the conservative movement has done, and the Lieberman Agreement simply has a prenuptial clause that all conservative rabbis make people sign, and under the Lieberman clause, you agree to give your wife a get if you get divorced. And that would be an enforceable contract in a state court. That is, you could go into the New Jersey state court and say, Your Honor, we're not asking you to adjudicate what a get is. We're asking you to adjudicate that these two people have a civil contract in which he's promised to give her a get, and he has to follow it. The other possibility, which the Orthodox are working out in Israel, but so far they haven't reached any conclusion, is to have something that is not a Lieberman, because the other issue is, and this again is way too complicated for today, if you force somebody to give a get, it's not a legal get. So in fact, the other problem with the New York get law is it may be unconstitutional, because it not only may be unconstitutional or should be unconstitutional, but it also may violate Jewish law. But the Orthodox in Israel are working towards a prenuptial in which the husband agrees to pay a cash payment of a significant amount of money weekly or monthly for the rest of his ex-spouse wife if he will not give her a get. And some Orthodox rabbis argue that this is because it would be a prenuptial agreement, it would be a civil contract, and therefore it would be kosher. And so if you don't want to give your ex, the woman you're no longer living with as your wife, a get, then you have to pay her amount of money. The other ones coming along the pike, and this is, again, probably will, because in the United States everything ends up in a court sooner or later, whether we like it or not. This will come along. Here's the conundrum I could leave you with. It is adultery for a Jewish woman who is married to have sexual relations with someone who is not her husband. If she does so, the child from those relations is a mamzer, who is a certain kind of illegitimate child who can only marry a limited number of other peoples. If she has artificial insemination from a sperm bank, is that adultery, and is the child a mamzer?
Yes, according to Rabbi Moses Feinstein, the decisive of Jewish law until he died in 1992.
On the one hand, but then on the other hand...
On the other hand, there's another... No, there are actually two leading rabbis who've come down on both sides of this question. And by the way, this doesn't even begin to ask the question about an egg donor. Or that is, if the woman receives an egg from another woman, what is the status of this child? These are, in other words, technology is hard enough for normal American law to cope with. And we have courts that can constantly change the law, and we have legislators that can constantly change the law, and we can take the technology and apply it to the law, or we can change the law to apply to the technology. Orthodox Jews don't have a Sanhedrin. They don't have a court of last resort. And so they are stuck in a technology in a world that is completely changed. And so one can only imagine that in New Jersey courts, Ron Dov is only the beginning, the tip of the iceberg of where religious law and civil law will intersect.